Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Hey guys, if you're new to this channel, just know this: I am not an attorney and I do not give legal advice. I just simply am a homeowner like y'all. I fought my own foreclosure, and people come to me and ask me for help, and I try to help as much as possible. But most of these people that do fight are pro se. So let's talk about the new case that we have going on here. Okay, so this is a case in the state of Texas, and there's the summons, and the complaint itself is for a quiet title action, and it's between Marlon Lewis and U.S. Bank and SN Servicing, the defendants. And he filed this on June 20th. There's a case number, and it's in Montgomery County in Texas, the 284th Judicial District Court. His house was scheduled for a foreclosure sale on the 2nd of July. So by filing this in the lis pendens, it's going to stop the sale. So let's take a look at his complaint real quick. Jurisdiction is Montgomery County, as you can see here. Legal description: his property. Factual allegations: basically, it goes over when he first got his house and who his bank is, and it talks about how the promissory note is only endorsed in blank. His corporate assignment of deed of trust are defective, and these are the exhibits here explaining that who owns it. Then you got defects that are in the chain of title. So he brings this lawsuit to address the defects that exist in the chain of title. And the defendant, by filing defective assignments of mortgage, has created a clouds on the property. The following issues that must be addressed are as follows, and it goes through: the promissory note is not endorsed by Freedom Mortgage Corporation, where it should be. At the bottom of the third page under plaintiff's endorsement, there is no endorsement by Nation Star Mortgage anywhere on the note. There is no endorsement on the note by U.S. Bank N.A. or U.S. Bank as trustee. There is no endorsement on the note by Citigroup Mortgage Loan Trust 2019C. There is no endorsements by the Igloo Series V Trust. There is no evidence of any attached allonges. And then the assignments also have defects, which we go over here. The assignor and the assignee have issues, guys. This is a common problem with most people's mortgages that have defects in their assignments. It says on here the assignee, the Citigroup Mortgage Loan Trust 2019C, has a closing date of August 27, 2019. The assignment was filed on October 22nd, 2019, which is 2 months past the date that it could legally enter this trust. A copy of the trust information is in a screenshot by Moody's is attached here too as Exhibit E, and that shows that the closing date for the trust was in fact when it was. The corporate assignment of deed of trust recorded January 18, 2023 as assigner U.S. Bank Trust National Association as trustee of Citigroup Mortgage Loan Trust 2019C is void because previous assignments fatally defective. The assignee in the assignment recorded January 18, 2023 to U.S. Bank Trust National Association as trustee of the Igloo Series V Trust is also defective because this trust does not exist. The Securities and Exchange Commission screenshot shows proof of this is attached here to as Exhibit F. So yeah, if the entities don't exist on the date that the assignments were made, then that makes them defective or ineffective. So, wherefore plaintiff alleges that the Igloo Series V Trust is not the true owner of the subject loan. The promissory note is blank and bears no endorsements. The assignments are defective, and the plaintiff seeks the quiet title to his property and remove the clouds which defendant has caused. Defendant SN Servicing and its purported trust has sustained no injury. A claim of default is not a claim of injury if the entity is not the rightful owner or person entitled to enforce. In Texas, the trustee must have legal authority to exercise the power of sale clause in the deed of trust. SN Servicing for U.S. Bank lack rights to enforce the deed of trust. There is no loan or contract that exists between the plaintiff and defendant. So he does a prayer for relief. Wherefore the plaintiff prays for judgment as follows against the defendant for an order quieting title to the subject property, removing defective deed of trust assignments, and a judicial declaration that the plaintiff is the full legal and beneficial owner of the property, for the filing fee and costs of the suit and attorney's fees, and for such other and further relief as the court may deem just and proper. Okay, and so, the usual stuff behind this. The exhibits are also attached to his complaint, which have his note and his mortgage and his, deed of trust, not a mortgage, etc. is all attached to his complaint, as you can see here. Now, something also interesting, well, after he filed his complaint and this pendant, he sent a letter to the company that's trying to sell his house, which is Prestige Default Services. And he's telling them to cancel the sale. So he's telling them, I'm writing to inform you to cancel the non-judicial trustee sale and auction scheduled for July 2nd, 2024. I wrote you a letter dated June 21st, 2024, and have not received a satisfactory answer. I have attached a copy of the complaint and list pendants for you to forward to your client as proof. This complaint will be served via personal process server shortly. It is illegal to invoke the power of sale in a non-judicial foreclosure without following the law. I have attached the Texas law regarding Section 51-002, sale of real property under contract lien. Every state has their own laws regarding foreclosures, and non-judicial states like Texas, they have to follow the law verbatim, and they didn't. So let's see what this says. The sale notice was not recorded in the county recorder's office. In Texas, notices of sale for foreclosure proceedings are required to be filed with the county clerk's office, which maintains records for these notices. The notice must be published weekly for 3 consecutive weeks in the local newspaper, which it wasn't. The first publication must be at least 20 days before the sale. The notice must include the time and place of the sale, description of the property, and the authority behind the sale. The notice must also be posted on the courthouse door and filed with the county clerk. Like I said, they didn't do any of that, so they're in violation. So basically that's it, and plus we also attach a copy of the law in case these attorneys are ignorant and they need to see it in writing. So they did not do what they're supposed to do. Another thing with his case that's interesting is his payment history, which we would create a spreadsheet showing. You can see the spreadsheet here. You can see the date column is the date. The amount is the amount that he sent in for his payment. The principal column is the amount that the bank applied to principal. The interest column is the amount they applied to interest. And then the escrow column is the amount that they applied to escrow. And then you have a remaining principal balance, fees that they charge, and notes explaining these things. What's interesting is he doesn't have a complete payment history. His payment history starts here in 2014 on 12/31/14, but he's missing payment history from 2007 to 2014. His principal balance being pretty high at $182,000, since his original loan amount wasn't even close to that. So they don't even have the right amount. And if you go down, you'll see from the highlighted things are things in question, by the way. And if you go down, you'll see 2018, 2019, and then it goes from 2019 to 2022 because he changed servicers, and the servicer that he had for that year won't give him any payment history, which is another thing he's going to go after him for. He was in bankruptcy, Chapter 13, from 2020 to 2023, guys. He was paying the bankruptcy trustee. The bankruptcy trustee was forwarding to the servicer, but as you can see here, the servicer was not applying the payments to his loan. Now, we are missing a lot of history here, but you can see that there's plenty of problems here. About 40-something thousand should have been applied to his principal. And it sure doesn't look like that ever happened. So guys, I just thought this would be an interesting video. He will be filing an amended complaint after they file a motion to dismiss. Usually what they do after they've been served is they file a removal notice and move it to federal court where it'll be. He'll file an amended complaint at that point, and he will bring up all these other problems with the payments not being applied and such, and we'll go from there. So guys, I just wanted to go over this with you, and if anybody has any questions about this, you can send me an email. Anyway, guys, thanks for watching my YouTube channel, and you know, I'm not an attorney, I can't give legal advice. But if you do have questions, you can send me an email and I'll try to answer them. And I hope everybody has a blessed day.